From a repeat offender facing decades behind bars after a DUI that took another's life.
Are you admitting here today that you were in fact operating a vehicle while under the influence of an intoxicant?
Yes, Your Honor.
And by that operation, you did cause the death of victim 1.
Yes, Your Honor.
To a woman pleading for leniency after trespassing.
Noted that there was no damage done, doesn't want to see a large punishment for this, and that's why there's no restitution requested.
Let's see how these judges handle 5 very different offenders. And we'll start with Mr. Thone, a repeat offender who dodged prison before, but now back in court for a DUI that killed an innocent victim. Let's see how the judge handles this.
We will go on the record in the matter 24 CF 184, State of Wisconsin versus Richard Thone. The state appears through District Attorney Kevin Schmidt in person. Mr. Thone appears in person in custody with counsel Lance Nelson. We're set today in this matter for a plea hearing. The parties have reached an agreement. Mr. Nelson, please recite it for the record.
Your Honor, the defendant, Mr. Thone, will be entering a plea of no contest to the single count and the information. There would be a joint recommendation at that point, Your Honor, that pre-sentence investigation would be ordered and that the state would agree at the time of sentencing to limit its incarceration recommendation at no more than 7.5 years. The defendant would be free to argue for any sentence.
All right. So he's pleading guilty to count 1, homicide by intoxicated use of a vehicle, second and subsequent, and then count 2, the PAC will be dismissed and merged in.
Correct.
All right. Mr. Thone, can you please put his microphone down for him, please? Mr. Thone, is that the agreement that you've reached with the state?
Yes, Your Honor.
I have in front of me the plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you thoroughly?
Yes, he did.
Did he essentially go over it with you word for word?
Yes, Your Honor.
And do you understand everything on this document?
Yes, Your Honor.
If you didn't understand something, did you ask your attorney to explain it to you?
Yes, Your Honor.
And he did so?
Yes, Your Honor.
Is that your signature on the second page?
Yes, Your Honor.
So you're pleading guilty to count 1, which is the homicide by intoxicated use of a vehicle, second and subsequent offense, a class C felony. Is that correct?
Yes, Your Honor.
You're 57 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, Your Honor.
Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt.
Yes, Your Honor.
And your attorney went over with you what the maximum possible penalties could be.
Yes, Your Honor.
You are currently receiving treatment for a mental illness or disorder. That would be Huntington's disease.
Yes, Your Honor.
But you have not had any alcohol, medications, or other drugs in the last 24 hours.
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand these rights completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you understand you will no longer have the right to a trial? You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
You understand that the state would have to prove as to count 1, homicide by intoxicated use of a vehicle while having prior intoxicated related convictions or revocation that on or around August 17th, 2024, in Burnett County, Wisconsin, you caused the death of victim 1 by the operation of a vehicle while under the influence of an intoxicant, and you have 1 or more prior convictions, suspensions, or revocations as counted under Wisconsin law. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you may be fined up to $100,000 or imprisoned not more than 40 years or both. Do you understand that?
Yes, Your Honor.
Do you further understand that upon conviction, the department shall revoke your operating privileges for 5 years?
Yes, Your Honor.
You also understand that upon conviction, the court shall impose a bifurcated sentence under Wisconsin law, and the term of confinement in the prison portion of this bifurcated sentence shall be at least 5 years, except that a court may impose a term of confinement less than 5 years if the court finds a compelling reason and places its reasons on the record. Do you understand that that mandatory minimum with the possible exception?
Yes, Your Honor.
Now, do you understand that the parties have reached an agreement for the court to order a pre-sentence investigation report? Do you understand what that report is?
Yes, Your Honor.
And it will have a whole lot of information about you and your life and your criminal history and a lot of facts about you. And it will have a sentencing recommendation from the Department of Corrections. Do you understand that I'm not bound to follow that recommendation?
Yes, Your Honor.
Do you understand that the agreement states that the state of Wisconsin is capped at the incarceration portion of 7.5 years, but your attorney is free to argue anything? Do you understand I'm not bound to follow the recommendation or argument of the state?
Yes, Your Honor.
I'm not bound to follow the argument or recommendation of your attorney, the defense.
Yes, Your Honor.
Do you understand that I'm free in my discretion to sentence you to what I feel is appropriate based upon the facts and the totality of the circumstances, which could be all the way up to the maximum possible penalty? Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over that criminal complaint with your attorney?
Yes, Your Honor.
In particular, there's a section called the probable cause section where it basically says what happened that day and why you were charged with the crimes. Do you remember that?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you were in fact operating a vehicle while under the influence of an intoxicant?
Yes, Your Honor.
And by that operation, you did cause the death of victim 1.
Yes, Your Honor.
And that you have at least 1 or more prior convictions, suspensions, or revocations.
Yes, Your Honor.
Mr. Nelson, may the court find use a probable cause section of the criminal complaint to find a factual basis?
We do not object, Your Honor.
Mr. Thone, has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and voluntarily and intelligently?
Yes, Your Honor.
That means you're telling me you fully understand what you're doing here today?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he looked at the discovery of this case and the evidence?
Yes, Your Honor.
Has he discussed that with you?
Yes, Your Honor.
Has he discussed that evidence and what the state must prove with the elements that the state must prove?
Yes, Your Honor.
Has he looked and discussed with you a potential of defenses you could have
Yes, Your Honor.
or a lack of defenses you have?
Yes.
Are you satisfied with his services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, I don't.
All right. Mr. Nelson, do you believe that Mr. Thone thoroughly understands everything that's going on here today?
Your Honor, I think it would be important to make a record on that. As noted in the plea waiver and questionnaire, Mr. Thone does have, he has suffered from something called Huntington's disease. It is a neurological disorder, Your Honor. It does affect his nerves. It affects, I think, his gait, his ability to walk, some of his motor functions. He doesn't necessarily sit still very well. Sometimes he can maybe have a tremor. It greatly affects his speech as well. I think that there are some there are some effects cognitively to some degree. I'll give the court an example. I did consider, I had the opportunity, I could have come down Friday afternoon and gone through the plea waiver and questionnaire with Mr. Thone. I thought out of an abundance of caution, maybe I would not do that. I thought that it might be a little bit wiser to make sure that I went through all of that with him right before the court would take the plea. The issue there is that I know that Mr. Thone does have some issues keeping a train of thought sometimes. I think he also has some issue with memory. And so it's hard for him to keep everything straight for a long period of time. And so, again, out of an abundance of caution, I thought it would be more appropriate for me to do all those things right before we had the hearing today. I have had some prior experience with Mr. Thone. And in my experience with Mr. Thone, Your Honor, he has some difficulties, but he is able to remember pertinent details for the most part. He makes very good decisions. He was given opportunity to make a number of decisions with respect to the representation in this case, and he made, in my opinion, sensible, wise, competent decisions. He asked many questions of me, Your Honor, and those questions were sensible questions. They showed an engagement with the issues in the case. And I have, although, as I said, there are clearly some issues with Mr. Thone, there are no issues in my experience with him that would substantively impact the knowing and voluntary nature of a plea today, or his ability to assist me in his defense in any way. He's been very helpful in that regard, and very, standard run-of-the-mill, no issues there. So, Mr. Thone, it's important to recognize that there are some issues. I think we've taken steps to be very, very careful in making sure that those issues did not creep into any substantive area of the representation. And I can certify to the court, Your Honor, that I am highly confident that Mr. Thone is completely aware of all the aspects that he needs to be aware of, and that his plea today is knowing and voluntary.
Thank you. And you went over the maximum possible penalties and the mandatory minimums.
We talked extensively about that, yes.
Excellent. All right. Mr. Thone, do you have any questions for the court before I proceed and enter a plea?
No, Your Honor.
As to count 1, homicide by intoxicated use of a vehicle, second and subsequent offense, a Class C felony, how do you wish to plead?
No contest.
Court will enter your plea here today. I will find that you understand your constitutional rights. You understand that you're waiving those rights here today. I will find a factual basis to accept your plea here today. I will find you guilty of that. I will find that you understand the charge and the maximum penalties. I will dismiss and merge in count 2 with count 1. A judgment of conviction will be entered today. Bond will hereby be revoked. The court will order a pre-sentence investigation report. Long form, agent does not need to appear, but should be readily available. In case questions arise, let's get a date and time set for a sentencing. The next available date and time I would have would be August 11th or 12th. And you pretty much have your pick. We could do the afternoon if you wish. Ms. Bauer, we are in victims' rights compliance.
Yes, Your Honor.
Do you know, are we going to have any victims make statements at the plea and sentence or at the sentencing?
One stated for sure.
Okay.
I would ask for the 12th.
The 12th, do you prefer afternoon or morning?
That wouldn't matter.
All right. How about 1 o'clock on the 12th? So schedule it probably an hour. And do you think,
Yeah.
how long do you think you'll need?
An hour.
arguments?
An hour is fine.
An hour. All right. From 1 until 2 on August 12th. All right. We will see you then. We are.
While Mr. Thone deals with the fallout of his DUI homicide, here's Mr. Sonnenberg, who pleaded guilty to endangering a cop's life, swore he couldn't recall it until he saw the video.
We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears in person in custody with counsel Renee Landgraf. We're set today in this matter for a final pretrial, but I've been informed that the parties have reached an agreement. Is that correct, Ms. Landgraf?
That's correct, Your Honor. I filed a plea questionnaire a couple days ago.
Can you please recite the agreement for the record?
My client will plead to count 1 with no modifiers. The remaining counts will be dismissed and read in. Joint request for a pre-sentence investigation, and the state is bound by the max of the PSI recommendation. Otherwise, free to argue.
All right. And Mr. Sonnenberg, that is the agreement that you have reached with the state?
Yes, Your Honor.
Victims' rights compliance?
Yes, Your Honor.
Basis for the public interest, Mr. Schmidt?
Mr. Sonnenberg's pleading guilty to the only felony in the complaint. The only thing we did is remove one of the modifiers. I think what's there encompasses everything I could conceive I would argue anyways.
Formal motion to amend count 1 to remove the modifier?
Yes, so made.
Granted. Mr. Sonnenberg, I have in front of me the plea questionnaire waiver of rights form, and it looks like you have that in front of you. Is that correct?
Yes, Your Honor.
Did your attorney go over this document with you thoroughly?
Yes.
Did she read it to you essentially word for word?
Yes, Your Honor.
And you understand it completely?
Yes.
If you didn't understand something, did you ask her to explain it?
Yes.
And she did so?
Yes, Your Honor.
Is that your signature on the 3rd page?
Yes, Your Honor.
You are pleading guilty to count 1 without the modifier, 1st degree recklessly endangering safety. Is that correct?
Yes, Your Honor.
How old are you?
I'm 42 years old.
And you can read, write, and you understand the English language?
Yes, Your Honor.
And you have not had any drugs, alcohol, or medications in the last 24 hours?
No, Your Honor.
No mental illnesses or disorders?
No.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
No.
She didn't do that?
Oh, yes, yes, yes.
Yes, and it's on top of that plea questionnaire as well, I believe. And did she go over with you the maximum possible penalties you face?
Yes, Your Honor.
Now, because you're charged with crimes, you are entitled to constitutional rights, and those rights are listed on that document in front of you. Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you.
Hmm.
You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life?
Yes, Your Honor.
You'll no longer be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
You understand that the state would have to prove as to count one, first degree, recklessly endangering safety. On or around December 16th, 2024, you recklessly endangered the safety of Officer Michael Zajac under circumstances which show utter disregard for human life. Do you understand what the state would have to prove?
Yes, Your Honor.
You understand that the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 12 and a half years or both?
Yes, Your Honor.
And do you understand that there is an agreement here for the court to order a pre-sentence investigation report? Do you understand what that report is?
Yes, Your Honor.
And that report will have a whole lot of information about you, your history, your criminal history, your life. And it will also provide a recommendation for sentencing from the Department of Corrections. Do you understand I'm not bound to follow that recommendation?
Yes, Your Honor.
And do you understand that per the agreement you've entered with the state, that the state of Wisconsin is bound by the maximum of the PSI recommendation? Do you understand that?
Yes, Your Honor.
But do you understand I'm not bound to follow the recommendation of the state in their sentencing recommendation?
Yes, Your Honor.
And I'm not bound to follow the recommendation of your attorney either?
Yes, Your Honor.
That I'm free in my discretion to sentence you to what I believe is an appropriate sentence based upon the facts of the case and the totality of the circumstances, and it could be the maximum possible penalty. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, if you look, there's a probable cause section that basically says what happened that day and why you were charged with the crimes. Do you
Yep.
remember that?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that through your actions and conduct that you did in fact show utter disregard for the human life of Michael Zajac?
Yes, Your Honor.
And you recklessly endangered Officer Zajac's life that day? Or his safety?
Yes, Your Honor.
Ms. Landgraf, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes, Your Honor. I also put factual basis in the plea questionnaire for each element
And you went over that with your client?
extensively.
And he fully understands the factual basis that you have placed on that plea questionnaire with each of the elements?
Yes, Your Honor. I would note that he doesn't actually remember the incident. He did watch the video, and once he watched the video, he said, yes, okay, I see how these elements are meant.
Excellent, thank you. All right, Mr. Sonnenberg, has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing here today
Yes, Your Honor.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes, Your Honor.
Has she answered all of your questions?
Yes, Your Honor.
Has she looked at this matter thoroughly?
Yeah,
Has
yes.
she looked at the discovery and the evidence in this case and discussed it with you?
Yes, Your Honor.
Has she looked to see if you have any defenses or a lack of defenses in this case?
Yes, Your Honor.
And has she discussed the strengths and the weaknesses of this case with you?
Yes, Your Honor.
Are you satisfied with her services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before we proceed?
What's the next penalty?
The max penalty? Maximum.
For the record, Mr. Sonnenberg does have a question for his attorney, and it has now been answered. Has it been answered thoroughly?
Yes, Your Honor.
All right. Ms. Landgraf, do you believe that your client is entering his plea freely, intelligently, and voluntarily? Do
Yes, Your Honor.
you believe he understands his constitutional rights and what it means to waive those here today?
Yes, Your Honor.
And he fully understands the facts of the case and the elements that the state would need to prove?
Yes, Your Honor.
And you believe he's entering his plea here today competently?
Yes.
All right. One last time to see if you have any questions, Mr. Sonnenberg.
No, Your Honor.
As to count one, first degree recklessly endangering safety, a class F felony without the enhancer or modifier, how do you wish to plead?
Oh, guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 or count, and the counts 2 through 5 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will revoke bond, and I will order the pre-sentence investigation report. Long form agent does not need to appear, but should be readily available in case questions arise. We need to set the matter for the sentencing. My next available to work with the PSIs would be either August 11th or August 12th.
I'm slotted for a 3-day trial. The 11th, 12th, and 13th as a number 2 in Eau Claire, so I
I
have no
can
idea how
do
that goes.
August 19th.
Anytime.
How about 1 o'clock on August 19th?
That work for you?
Yes.
Probably an hour or two. August 19th. All right. 1 o'clock, August 19th. Will we have victim statements?
I'm not for sure, Your Honor.
Okay.
This time it's Mr. Koig, charged with identity theft while in federal prison. He's still trying to cut a deal. Let's see how the judge handles this.
We will go on the record in the matter 22 CF 243, State of Wisconsin versus Sean Koig. The state appears through District Attorney Kevin Schmidt in person. We have Ryan Reed, defense counsel, by video conferencing with approval of the court. We have Sean Koig appearing by Colorado Federal Prison by telephone Zoom with approval of the court. We're set here today on a return on warrant initial appearance. The warrant is now quashed. I believe that the parties have reached an agreement in this case. Is that correct, Mr. Reed?
Yes, Your Honor.
Can you please recite the agreement that's been reached?
Thank you, Your Honor. I anticipate my client entering a guilty plea to count 2. The state would be dismissing and reading in counts 1, 3, and 4, and we would be resolving our sentencing with a joint recommendation of court costs, and the sentence is to run concurrent with the federal count as well.
It's only going to be court costs?
The 6 months jail concurrent to the federal.
My apologies. That is correct, Your Honor.
6 months jail to run concurrent. All right, and we're taking care of that here today. All right, and I have a plea questionnaire waiver of rights form in front of me. Mr. Koenig, can you hear me okay?
Yes, ma'am.
And I'm gonna need to turn you up just a little bit. Just give me 1 second. All right, Mr. Koenig, were you able to go over that criminal or the plea questionnaire waiver of rights form with your attorney?
Yes, ma'am.
And did you have a copy of that when he was going over it with you?
Yes, ma'am.
And so when he went over it with you, did he explain it thoroughly with you? And did he essentially go over it with you word for word?
Yes, ma'am.
And so do you understand it completely?
Yes.
And is that your signature on the second page?
Yes.
You're appearing by telephone Zoom conferencing, and your attorney's appearing by video conferencing. Do you understand that you would have the right to be here in person in front of everybody and with your attorney?
Yes, ma'am.
Are you asking the court to allow you to enter a plea and to be sentenced by telephone Zoom conferencing?
Yes.
If you have any questions or concerns and you need to speak with your attorney, let me know and I can send you into a confidential breakout session, okay?
Can I talk to him real quick?
Yes, really quickly, you sure may. Just give me 1 second. I don't know which one to, I'm gonna get rid of, just a second. I need to get rid of, I don't know whoever this other SPD is, so. All right. Need to. There we go. I'm opening the room right now. You can have a few minutes. We are briefly adjourned. Back on the record, Tim, appearances as previously noted. Mr. Koenig, was that enough time?
Yes, yes, ma'am.
All right.
Your
Okay,
Honor?
so your attorney, yes, Mr. Reed.
If I may, Your Honor, we were hoping that the judgment of conviction could reflect concurrent to the federal sentence, also allowing the sentence to be served in a halfway house. Mr. Koenig, am I getting that right?
Yes, yes, yep.
Well, I don't know. That's part of a deal. That's part of an agreement. So that would have to be discussed with the district attorney.
So I can just give the court some background. We reached an agreement a year ago to do concurrent jail time prepay restitution. He actually prepaid the restitution a year ago to our office
That's
directly.
already paid.
And then his attorney died, and without an attorney and being in the federal prison system, he just couldn't continue the case until now, just recently. So the concurrent jail with him was supposed to have started a year ago.
So
So if we want to just do costs, I'm fine with
yeah,
that.
because so quite honestly, jail is really fictitious. Doesn't really exist. All right, okay, that's fine. Sounds like it's in agreement. All right, so you understand that, Mr. Koenig?
Yeah, so we'll like all right, that's what I'm saying.
There's
is,
not
like,
gonna be
like-
jail. You don't have to worry about that.
No, I know. Will I be able to serve this time in a federal halfway house, this 6 months? I need
Again,
some-
there's not going to be any jail.
All right,
That's changed now because it's been so long and you've been serving time in prison, and if anything goes concurrent, really, there's not a separate sentence. All right, so Mr. Koenig, did you go over that plea questionnaire thoroughly and you completely understand it?
yes, ma'am.
And so you're pleading guilty to count 2, misappropriating an ID, obtaining money, a class H felony.
Yes, ma'am.
You are 37 years old. You have 12 years of schooling. You can read, write. You understand the English language.
Yes,
Did your attorney go over with you your constitutional rights?
yes, ma'am.
Do you understand them completely?
Yes,
Do you need me to go over them with you in any more detail?
no,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
yes,
You will no longer be able to vote in any election until your civil rights are restored.
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation? Do
yes,
you understand the state would have to prove on or around June 2nd, 2021, you intentionally used personal identifying information or personal identifying documents, personal checks of victim 1 to obtain something of value or benefit without that person's authorization or consent by representing that you were that individual or acting with the authorization or consent of that individual. Do you understand what the state would
Yes.
have to prove?
yes, ma'am.
You understand that upon conviction, you face a fine of up to $10,000 or up to 6 years of incarceration or both?
Yes,
You also understand that the agreement here, at first it contemplated a 6-month jail sentence, but that was renegotiated because you prepaid that restitution. And now that there's an agreement for costs only, do you understand that I'm not bound to follow that? I could sentence you all the way up to that maximum penalty if I did think that it was warranted. Do you understand that?
yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Did you go over the criminal complaint with your attorney, and in particular that section called the probable cause section that basically says what happened and why you were charged with the crime?
Yes,
For the most part, are those facts accurate?
yes, ma'am.
Are you admitting here today that you in fact did use somebody else's identity for financial gain?
Yes,
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
no, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes,
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, ma'am.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before we proceed?
Will there be a way I can get a disposition paperwork sent here?
Something will be sent, yes.
Thank you.
As to count 2, identity theft, financial gain, or misappropriating ID to obtain money, how do you wish to plead?
Guilty?
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. We'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. Counts 1, 3, and 4 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. This case was part of a larger, string of similar acts that also occurred in Minnesota. It's the basis of why he got revoked and is in the federal prison system now. So part of his punishment now is for this offense. I believe this is now the last one in that string of offenses around 21, 22 that still exists and is out there. He actually tried to resolve this previously, and prepaid restitution, but his attorney died and the case continued for another year, really because of that and the difficulties of changing attorneys with the public defenders while having this person in the federal prison system. So I think all things considered, this is appropriate. Thank you.
All right, thank you. Mr. Reed.
Thank you, Your Honor. These matters are very serious, but as the state notes, Mr. Koenig is currently in prison, has prepaid restitution. We believe, given the Galleon factors, the joint recommendation is appropriate, and we ask the court to follow it.
All right, Mr. Koenig, do you have anything that you wish to say or tell the court?
I'd just like to apologize to the victim. I was on drugs, and I apologize to the victim.
Thank you, Mr. Koenig. Do you have an inmate number?
20857-041.
Thank you. Okay, after hearing the facts of this case and that you wanted to resolve this, you prepaid restitution, and that you were revoked and now you're sitting a prison sentence in Colorado federal prison, essentially stemming from your actions here. I think that ordering the restitution in the amount of $865.75 is appropriate, along with court costs and fees in the amount of $518. You've already sat prison time for this. Having additional jail time and or prison time won't serve any purpose other than additional punishment, but it sounds like you've learned something and you are trying to change your life for the better, and that the community is not at harm or at risk, at least at this time. So I will assess the fines, the fees, and that restitution, which you've already prepaid. I'm ordering you to provide your fingerprints. I'm ordering you to provide your DNA. You have the right to request that be expunged through a written letter to the Department of Justice. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is ordering that you pay back your court costs and fees in the amount of $50 per month until paid off in full. Department of Corrections will be able to collect all of that court costs and fees as a percentage determined by the Department of Corrections to be reasonable while you're in the state prison system. When you are released from the prison system, then that $50 a month is your definite payment. So I would recommend you pay it off all as quickly as you practically can. I believe that covers everything, except if you fail to pay your fines and fees, not only will a civil warrant or civil judgment be entered against you, but a warrant will, and you could sit up to 6 months in jail. All right, Mr. Schmidt.
Yes, that sounds good.
Anything that I'm missing, Mr. Reed?
No, Your Honor.
Okay, thank you. Then we are
And this one centers on Mr. Mays, who blew off probation and racked up 4 separate violations. Let's watch this.
Good morning, sir. You're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation. Motion to revoke has been filed. What's the announcement?
Your Honor, if the court would entertain going through the motion, we could enter pleas and then not get an updated pre-sentence.
There's no agreement?
No, Your Honor.
Give me just a second.
Good morning.
Good morning. Mr. Mays, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And will he waive the formal reading of the motion?
So late.
Mr. Mays, in cause number 20-36100, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 13th of 2021 for burglary of a habitation, and that was a 3-year deferred probation. Is that correct? Yes. I'm assuming that's been extended otherwise. So it alleges in that probation, or in that motion, that you violated your conditions of probation. Count 1 alleges that you failed to report to the probation department as required for the months of October and December of 2024 and January of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of participating in the GED program. Is that true? Just today it's just true or not true, and then we'll get explanations later. It's not true, okay. Count 3 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, that MRT program. Is that true or not true? And count 4 alleges that you're behind in your court assessed fees. As of January 15th of 2025, you were $3,685 behind. Is that true or not true? All right, did you enter your pleas of true to counts 1 and 4 freely and voluntarily? Speak up, please. And did you plead true to those because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that we can have a sentencing hearing. I'll get probation to do an updated report. Looks like we probably will only need a probation officer, so we can do that on a normal day. Shouldn't take long. All right. And so you need to stop and talk to probation on your way out of the courtroom so that they can make sure and tell you what you need to do to get ready for that sentencing hearing, okay? All right, we'll see you back then.
Finally, we have VA Moody, a woman facing charges for entering a home without consent. Let's see how the judge handles this.
We will go on the record in the matter 25 CM55, State of Wisconsin versus Beta Moody. The state appears through District Attorney Kevin Schmidt in person. Ms. Moody appears by video conferencing in custody in Polk County Jail. We have counsel Joel Feliski in person. We're set today in this matter for a status conference. Mr. Feliski, can you please update the court?
Thank you, Your Honor. I have received an offer from the state to resolve this matter. I've communicated this offer to Ms. Moody. I believe she would like to accept it. It is an offer to plead to the count of criminal trespass to property. The parties are making a joint recommendation for court costs and credit for time served. I believe she has 11 days jail credit.
11 days jail. Ms. Moody, would you like to take care of this here today, or can we?
Yes.
Victims' rights compliance?
We are.
We are. Would you like to take care of this here today, Ms. Moody?
Yes.
All right. And Ms. Moody, you're appearing by video conferencing and your attorney's here in person. Do you understand that you have the right to be here in person to enter a plea and to be sentenced?
Yes.
Are you waiving that right and wishing to enter a plea and be sentenced by video conferencing?
Yes.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know so I can send you to a confidential breakout session. I will put him in a Zoom room, okay?
Okay.
And if at any time you cannot hear something or see something, let me know so that I can make sure you've heard and understood everything, all right?
Okay.
Okay, so Ms. Moody, how old are you?
22.
And you can read, write, you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Any mental illnesses or disorders?
No.
You understand that you would have certain constitutional rights, but by pleading guilty, you're waiving those rights?
Yes.
You'll no longer have the right to a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you'll no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around March 22nd, 2025 and March 24th, 2025 in Burnett County, Wisconsin, you intentionally entered the dwelling of J.B. without consent of the owner, and that includes the dwelling as no person was lawfully upon that premises under circumstances tending to provoke a breach of peace. Do you understand what the state would need to prove?
Yes.
You understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months of incarceration or both.
Yes.
You understand that the agreement here is for 11 days of jail and for court costs. Do you understand that?
Yes.
You understand I'm not bound to follow that. That means I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the criminal complaint with your attorney? And in particular, there is a section called the probable cause section that basically says what happened those days and why you were charged with the crime. Do you remember that?
Yes.
And for the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did on or around those dates intentionally enter the dwelling of JB without JB's consent?
Yes.
And that tended to provoke a breach of peace?
Yes.
Mr. Feliski, may the court use the probable cause section along with the statements made by your client to find a factual basis?
So stipulated.
Ms. Moody, has anyone made any threats or promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today.
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Got coffee in here?
Yeah.
You're not supposed to.
Has he answered all your questions?
Yes.
Are you satisfied with his services?
Yes.
You have any questions for the court or for your attorney before we proceed?
No.
As to the sole count criminal trespass, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole count. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think with the jail she has and that she has money posted abuse for a fine is sufficient in this case. The victim noted that there was no damage done, doesn't want to see a large punishment for this, and that's why there's no restitution requested. I think there was some understanding and empathy from the victim about the defendant being homeless and having mental health issues. I know she's got other cases in Polk, a larger volume of cases, but for here, with what she did here, I think that the jail she sat and the financial penalty is sufficient. Thank you.
All right, thank you. Mr. Feliski?
Thank you, Your Honor. I concur with these statements made by the state. I will reiterate that Ms. Moody does currently have 11 days jail credit. she's here today taking accountability for what happened, taking responsibility for what happened. She will, to my understanding, remain in custody on those Polk County cases. So I believe that the community is sufficiently protected here. I think that this is a appropriate resolution for this matter, and I'd ask the court to follow the agreement. Thank you.
Thank you. Ms. Moody, do you care to make a statement today? You don't have to, but it is your only opportunity to let me know anything you want me to know.
No.
This is not a very serious case. If I'm recalling the facts of this case correctly, Ms. Moody was breaking in. She needed a place to stay. And essentially, that's what she was doing. She didn't damage the place. And I think at the time she was working, I think if I'm recalling again correctly, is at T-Dogs. And so it's not like she was trying to break into burglarize or trying to break into destroy things. She was trying to have a place to stay while she's working and to do that instead of anything malicious. I think that the agreement is appropriate here, and it sounds like the victim is supportive of having Ms. Moody get services or help and not have a huge, swift, hard punishment. So I think that the agreement is appropriate with 11 days of jail, and she does have 11 days of jail credit, and I will order $500 in court costs and fees. She has $500 posted, so she's good to go there. She has 20 days to appeal. Should she fail to appeal within 20 days, she does lose that right. I am ordering your DNA. The jail will make sure that we have it. You have the right to request it be expunged through a written letter to the Department of Justice. I believe that covers everything, Mr. Schmidt.
Nothing else for me.
Mr. Flisky.
Nothing further.
All right, thank you, Ms. Moody. You are adjourned.